Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoyed this legal education content, and today will be the day I earn that subscription. For today's story, we are going to continue our theme of learning from Darrell. Darrell, as I'm sure you are well aware, was convicted today, very justly, because he was very guilty. He was very guilty. So very guilty. Darrell Brooks was so incredibly very guilty. And fortunately, the trial, despite Darrell's attempts to delay the inevitable and stall and become basically just a jackass and confirm to us that he's just generally not a good person, as if we had any doubts, the trial has come to an end. And come to a just end. I am happy. I am very happy. This is a good day for us all. So, with his conviction now on the books and sentencing soon to occur, we must now turn our attention to the next step of the process once the sentencing is done. And that would be, of course, appeal. Because he has a right to appeal. The courts have said that we all have one right to appeal. Now, of course, he doesn't have to appeal. There's no mandatory appeal. Sometimes in death penalty cases in particular, there's mandatory appeals. But he's not entitled, he doesn't have to take his appeal. But he's going to. So yeah. So he gets one appeal as a matter of right. Anything past that is, discretionary. Probably not so much for him. So probably a one and done, I would imagine. Anywho, he also has the right to an attorney in his appeal because it's part of your due process rights. You have a right to an attorney, the assistance of counsel. This right exists at the trial stage and it exists at the appeal stage. Now, of course, Darrell can continue to represent himself and, God willing, he will. And no matter what he chooses, he might be forced to. We'll discuss that in a second. But he does have the right to an attorney. So I can't imagine where he'll find one that he could hire. Or that he could afford one. So therefore, the public defender's office. The public defender's office does appeals too. It's part of their job, right? So he has the right to an attorney from the public defender's office. Now, the public defender's office, or any attorney for that matter, their ethics rules would be the same, has twin duties. All attorneys have twin duties. They have the duties to their client, and they have the duties to the court, because all attorneys are officers of the court. We're all officers of the court. So we have duties to our clients, and we have duties to the court. And when these things conflict, usually the court wins. Because, the system is more important than one individual when there's conflict. Now, not always, of course, is there conflict, but there are rules for us all. Right? So an attorney faced with an appeal for Darrell may find legitimate grounds of appeal. I'm not foreclosing the possibility. I'm not saying there's no legitimate grounds of appeal, although during the trial phase themselves, I haven't found any. And, it seemed to me that he competently waived counsel and was proving his competence every moment, despite his protestations to the contrary, and proving that he was intelligent within the meaning of the law. Within the meaning of the law, intelligent. So, yeah. And apparently I'm having a bad hair day, so let me just put this on. It fixes bad hair problems all around. Anyways, so he's competent, and he competently waived his right to an attorney, and he presented his case, and he lost, and he lost horribly. So I don't really see any grounds of appeal that are possible. But, maybe there's a trained criminal defense attorney out there who disagrees with my assessment. And if they do, I respect their opinion. I don't see anyone, but then again, I'm not a trained defense attorney. Nor am I a trained defense attorney in Wisconsin. So, maybe someone will think of something. But what if they don't think of something? Right? What if there is nothing? What if there's nothing to do? This is a bit of a problem. Because an attorney cannot make a frivolous case. You can't make a frivolous argument. I can't go to the Court of Appeals and be like, but sovereign citizen, though. because, no, obviously, right? I can't do that. It is not a legally cognizable argument, and I don't have any reason for why the court should reconsider that. So, like, I know every court has said no to the sovereign citizen, but you should be the first court yet to say yes. And here's some reasons why, and they're really good reasons. Yeah, not so much. I don't really have really good reasons for overturning all the precedent ever when it comes to the whole sovereign citizen thing. Not so much. So, like, what do you do if you're the attorney in this situation? You've been appointed to represent Darrell Brooks, and you have to zealously represent your client, because that's your duty, to zealously represent your client, but also you can't make frivolous arguments. So what do you do? If you have arguments, great, make them. What if you have no arguments? That's the scenario. Well, the Supreme Court fortunately created a way to deal with this problem called an Anders brief. And it's named after the case we're going to be discussing today. Anders versus California, U.S. Supreme Court in 1967, where the U.S. Supreme Court recognized this problem and created a solution. The Anders brief. Okay, so let's go ahead and read this and learn a little bit from this. Mr. Justice Clark delivers the opinion of the court and writes, "We are here concerned with the extent of the duty of a court-appointed appellate counsel to prosecute a first appeal," and they're a defense lawyer here. So prosecute in this sense just means to forward their client's interests, right? So prosecute here doesn't mean prosecute in the sense of putting him behind jail. Prosecute here means in the sense of prosecuting the case, which is to represent his client. Okay, so we're here with the concern with the extent of the duty of the court-appointed appellate counsel to forward his client's interests in a first appeal from a criminal conviction, which there's that as a right, after the attorney has conscientiously determined that there's no merit to the appeal. So what do you do if there is no merit to the appeal? All right, so let's discuss a little bit about the case of Anders and how we got to this place. After he was convicted of felony of possession of marijuana, petitioner sought appeal and moved the California District Court of Appeal to appoint counsel for him. Such motion was granted because, of course it was. However, after study of the record and consultation with the petitioner, the appointed counsel concluded there was no merit to the appeal. There is no hope. He so advised the court by letter and at the same time informed the court that petitioner wished to file a brief on his own behalf. After this juncture, petitioner requested the appointment of another attorney. This request was denied, and the petitioner proceeded to file pro se. Says like, well, my attorney doesn't believe in me. Can I have another one? No, you can't. You're entitled to an attorney, not an attorney of your choice. This attorney has determined there's no hope. Yeah. So, no. But you can file one on your own. The state responded, and the petitioner filed the reply brief. On January the 9th of 1959, the District Court of Appeal unanimously affirmed the conviction. Unsurprisingly. So guy convicted over here wrote his own brief, which amazingly did not persuade the Court of Appeals that he should be, not convicted. I like to not be convicted very much. The Court of Appeals isn't buying it. All right, so we're going to try to come at this from the side on a habeas because we say my federal rights have been violated, right? I've lost my trial. I've lost my appeal. I've lost all my direct attacks, but that's okay. I'm going to try to come at this from a side on a habeas. I'm going to go to federal court now and say they violated my rights because I wasn't given an attorney. Okie doke. So he files an application for a writ of habeas corpus. Hey, you violated my federal rights in the District Court of Appeal to have the case reopened. In the application, he raised the issue of deprivation of right of counsel in his original appeal because of the court's refusal to appoint counsel at the appellate stage. Well, that's not exactly right. We did appoint counsel. They just gave up because they said you have no hope. Yeah. The court denied the application on the same day in a brief unreported memorandum opinion. Yeah. No. The court stated that it had again reviewed the record and determined the appeal to be without merit. The court agrees with the appointed defense lawyer's assessment. The court also stated that the procedure to be followed was prescribed in a case called In Re Nash, was followed in this case. So there was some state law dealing with this issue, but of course, were now in federal court on federal law. So the state of California had invented a solution. And now the federal courts have to decide whether that state invented solution is compatible with federal law. Okie doke. The court also stated that the procedures prescribed in In re Nash was followed in this case. On June the 25th of 1965, petitioner submitted a petition for writ of habeas corpus to the Supreme Court of California. No. Among other issues, the petitioner claimed that both the judge and prosecutor commented on his failure to testify, contrary to a holding. We have concluded that California action does not comport with fair procedure and lacks equity that is required by the 14th Amendment. Okay, so we have some issues with what California did, but let's clarify what California should have done. Fine. For a decade or more, a continuing line of cases has reached this court concerning discrimination against an indigent defense on his first appeal. The poor are not getting their fair shake in the appellate system. Beginning with Griffin, where it was held that equal justice was not being afforded to the poor applicant when the nature of the review depends on the amount of money had, and continuing on through Douglas versus California, this court has consistently held invalid procedures where the rich man who appeals as a matter of right, and as I said, you get one appeal as a matter of right, so everyone has the appeal as a matter of right, the rich and the poor, but the rich man who appeals as a matter of right enjoys the benefit of counsel's examination of the record, research, and marshaling of arguments, while the poor, not so much. Because, there was a time when the poor did not get the right to an attorney for an appeal. There was also a time, incidentally, where they didn't get the right of an attorney for the trial either. But, there was also a time where they didn't get the right for the appeal, right? Okay. So that's what they're talking about. Indeed, the federal courts, the advice of counsel has long been required whenever defendant challenges a certification appeal is not taking in good faith, and such representation must be in the role of an advocate. Attorneys got to attorney. Rather than as an amici, rather than as someone who's just merely filing as a side. No, attorney got to attorney, right? You're an attorney, you got to attorney. You can't just file a friend of the court brief. You're not a friend of the court, you're a friend of the person you represent, right? In Ellis, we've concluded if counsel is convinced after conscientious investigation that appeal is frivolous, of course, they may ask to withdraw. So yes, you can withdraw. If the court is satisfied that counsel has diligently investigated the possible grounds of appeal and agrees with counsel's evaluation of the case, then leave to withdraw may be allowed and leave to appeal may be denied. So our prior solution to this problem that we had in 1958, we said in the case of Ellis, we said, hey, if the attorney concludes there's no hope, they can just withdraw, and that's cool. So that's what we said in 1958. In Gideon versus Wainwright, which says, you have the right to an attorney at the trial stage, the Sixth Amendment requirement, the accused shall enjoy the right to have assistance of counsel for his defense, was made obligatory to the states by the 14th Amendment, holding that in our adversary system of criminal justice, any person hailed into court who's too poor to hire a lawyer cannot be assured a fair trial. We continue to adhere to those principles. So in 1958, the U.S. Supreme Court said, well, your attorney can just withdraw from the appeal, and that sucks to be you, because we hadn't yet decided that you have a right to an attorney ever in 1958. We hadn't said that you have a right to an attorney ever in 1958. In 1963, we said, oh yeah, maybe you have the right to an attorney at the trial stage. So maybe our decision in Ellis maybe needs to be re-examined or reconsidered in this new and exciting light, where it's well, of course you don't have a right to an appellate attorney because you don't have a right to a trial attorney. Oh wait, you have a right to a trial attorney. Okay, maybe you have a right to an appellate attorney too. Maybe we should take another look at that one. Probably a good idea. Great. In petitioner's case, his appointed counsel wrote the District Court of Appeal saying, I will not file a brief on the appeal, as I am of the opinion that there's no merit. I visited and communicated with Mr. Anders and have explained my views and opinion. He wishes to file a brief in the matter on his own behalf. Cool. The District Court of Appeals, having examined the record, affirms. We believe that counsel's bare conclusion was not enough. So this is the problem, right? This is where the procedure kind of failed. California, incidentally, was following Enders, but of course, Enders is about to very shortly not be good law. So, yeah. So California was doing what the Supreme Court told them what to do before, but now they're going to change their mind, which the Supreme Court gets to do. So before he's just like, nope, I'm out. And the Supreme Court says, nah, that's not so great because we think you have the right to an appellate attorney too. So we're going to require a little bit more than nope. Okay. It smacks of the treatment that Eskridge had received, which this court had condemned, that permitted a trial judge to withhold a transcript if he found defendant had been accorded a fair and impartial trial. And the court's opinion, no grave or prejudicial errors. Yeah, we're not even going to give you a transcript of the trial because we're so convinced that there was no error that you don't even have the right to a transcript. Supreme Court had a problem with that one too. It's like maybe if he has a right to appeal, maybe he should have, a transcript so the Court of Appeals can see like what happened. That'd probably be helpful. So you get a transcript. Great. Such a procedure, this court has said, is not adequate substitute for the right of full appellate review to defendants. Yeah, the trial judge saying, I'm just not going to give you a transcript at all because your case is so weak. That's the trial judge. Not really so much a substitute for, appellate judges who, by necessity, review the record. But now there's no record, so that's a problem. And we think the trial judge saying, it's totally cool, there's nothing for you to look at. Well, that presents a bit of a problem. The trial judge deciding they're on appeal. We think leaves a little bit to be desired, so maybe give him the transcript. Yeah. Okay. Even if you cannot afford the expense, we have to give it to you for free. And still another case in which the state officer outside the judicial system was given the power to deprive an indigent of his appeal by refusing to order the transcript merely because they thought the appeal would be unsuccessful. We reversed. Now it's even slightly worse in that case because now it's not the trial judge saying, I'm not going to give you the transcript. Now it's just a guy, presumably in the executive branch. Some executive official somewhere saying, okay, no, you don't get an appellate, an appellate brief, or more to the point, you don't get a transcript of your trial. So the trial court saying you don't get a transcript. We think maybe the trial judge could potentially be conflicted in that decision. So no. Oh, that's all right. We'll solve the problem by giving it to someone in the executive branch, the very branch that's responsible for prosecuting you in the first place. So Supreme Court's not buying that one either. We think maybe random executive guy making the determination is also problematic. So no. Okay. So in this particular case, however, we have the transcript. So that wasn't the problem. We do have the transcript, yay. But the attorney says nah. The one that was appointed to represent him says nah. His advocate says nah. So now it's not the state doing it. It's his attorney who's like, nope. And I'll remind you, his attorney to some degree is required to say nope, at least under some circumstances, because as I mentioned, an attorney has twin duties, both to their client and to the court, and they can't forward frivolous arguments. If there are non-frivolous arguments, great. Maybe Darrell Brooks has some non-frivolous arguments. I don't know. I haven't been paying attention to every second of this trial. I don't really see any. But, maybe some attorney, really putting on their thinking cap will find one. I don't know. But if they don't, well, that's kind of the situation that Anders was in. He filed a no merit letter with the District Court of Appeal, whereupon the court examined the record itself and affirmed judgment. So the Court of Appeals reviewed the transcript, absent counsel, and said, no appeal. Or we don't want to give your appeal. So they proceeded without him. On a petition for a writ of habeas corpus some 6 years later was found the appeal had no merit. It failed, however, to state simply whether it was frivolous or not, but after consideration simply found to be without merit. So that's another possibility. Like, it doesn't necessarily need to be frivolous, maybe. Without merit and frivolous are not necessarily the same thing. Frivolous is like a 4-letter word to attorneys. That means, like, it's broken beyond all hope. So without merit doesn't necessarily mean frivolous. Those could be different things. I mean, to some degree, every appeal that fails is without merit because it failed. So those are definitely different things. It failed to say, however, it was frivolous or not, or simply without merit. The Supreme Court, in dismissing the habeas application, gave no reason at all for its decision, and so we don't know. We're talking about the Supreme Court of California at this point. The Supreme Court of California didn't want to add its wisdom to the mix, so we're not quite sure what they were doing. We cannot say there was a finding of frivolity, either by California courts or that counsel acted in any greater capacity than merely as an amici when he condemned Ellis. So yeah, attorney not attorneying. He's basically telling the court he thinks there's no hope instead of representing his client. So this is not quite great enough. Okay. Hence, California's procedure did not furnish petitioner with counsel acting in the role of an advocate, nor to provide full consideration and resolution of the matter as is obtained when counsel is acting in that capacity. We're going to need a little bit more. The necessity for counsel acting is highlighted by possible disadvantage the petitioner suffered. In his pro se brief, which was filed in 1959, he urged several trial errors, but failed to raise the point that both the judge and prosecutor had commented to the jury regarding the petitioner's failure to testify. I don't know whether or not he did or not, whether or not there was a comment or not on that, but in his pro se, he failed to raise the issue, and if you don't use it, you lose it, right? If you don't tell the Court of Appeals about it, they can't reverse on that basis. So I don't know whether or not it happened or not. I don't know even if it happened, whether or not it's a problem or not. You know, we need to know more, but he failed to raise the issue, so that's a problem. In 1965, of course, the Supreme Court outlawed this ability to comment, so probably a problem if it happened, but, you know, we could always look into it more. They can't comment on the refusal to testify. So if they did, you know, without some curative instruction or some other circumstance, we might have a problem. But we don't know because he never raised the issue. So the Court of Appeals didn't consider it. Okay. The constitutional requirement of substantial equality and fair process can only be obtained where counsel acts in the role as an active advocate in behalf of his client, as opposed to just like a friend of the court. Advocate got advocate, yo. The no merit letter and procedure it triggers do not reach that level of dignity. Counsel should and can honor and without conflict be of more assistance to his clients and the court. His role as advocate requires that he support his client's appeal to the best of his ability. Zealously represent your client to the best of your ability. That's basically like Rule 1. It's literally Rule 1.1, to be honest. It's not almost. It's literally Rule 1.1. Be a zealous advocate. Of course, if counsel finds his case to be wholly frivolous, after conscientious examination, he should advise the court and request permission to withdraw. So if frivolous, you can request permission to withdraw. But here's where it comes in. Here's where we get the Anders brief, right? Because this is all about the Anders brief. So here's where the Anders brief comes in. This is where it comes from. That request, however, must be accompanied by a brief referring to anything in the record that might arguably support the appeal. So you have to like highlight everything you think could potentially be possibly an appellate issue. So you can say there's nothing here, but you got to do your best to say here's everything that maybe someone could think is an issue. Right? But you can petition to withdraw. But you also got to submit the brief. Okay. A counsel of the brief should be furnished to the poor person, and time allow him to raise any points he chooses. The court, not counsel, then proceeds after full examination of all proceedings to decide whether the case is wholly frivolous. So because the attorney is making a request to withdraw, right? Attorneys have a request to withdraw. Excuse me 1 second. I'm getting some random email from someone who apparently is lost. Okay, I'll send them back a message so that they can figure out what's going on in their life. Okay, continuing on. Random message, please, like, I'm lost or whatever, I need help. And I'm like, yeah, you've reached the wrong person. Okay, great. Carrying on. Let's see. All right, so where were we? So you make a motion to file for appeal withdrawal, and this incidentally is also true at the trial stage, right? Once you reach a certain stage of proceedings, the attorney can't just like leave. You have to ask for permission. You have to make a motion to withdraw, among other factors that your withdrawal will not prejudice the client because of the stage of the proceedings. You can't just be like halfway through a criminal case and be like, I don't want to do this anymore. I'm out. No, the court can make you continue working. You're in this now. Basically, there's basically a point of no return. You're in this, and so basically, same thing for the appeal, right? You've been appointed, court appointed counsel, and so you're in this until the court relieves you, and so you have to ask and ask nicely. Ookie doke. All right, so the Court of Appeals has to decide whether it's frivolous. If so, it may grant counsel's request to withdraw and dismiss the appeal insofar as federal requirements are concerned, or proceed to a decision on the merit if state law requires. So, you can grant the dismissal for frivolousness and then decide whether or not it's frivolous. So, okay. On the other hand, if it founds any legal points arguable on the merits and therefore not frivolous, it must, prior to the decision, afford the indigent the assistance of counsel to argue the appeal. So if there's anything non-frivolous, then you can't get out. So, okay. This requirement would not force appointed counsel to brief his case against his client, but would merely afford the latter that advocacy which the non-indigent is able to obtain. Right? So, like, if you hired private counsel, they would presumably do this for you too and telling you why they can't represent you. So, okay. It would also induce the court to pursue all the more vigorously its own review because of ready references not only to the record, but also legal authorities furnished by counsel. So we're gonna make you give some assistance to the appellate court on some level. The no merit letter, on the other hand, affords neither the client nor court any aid. The just nope, I'm out doesn't really help. You gotta do a little bit more than that, counselor. You're an officer of the court. You're in this, baby. The former must shift himself entirely, while the court has only the cold record, which it must review without the help of an advocate. Yeah. Moreover, such handling would tend to protect counsel from constantly increasing charge that he was ineffective and not handle the case with diligence. So, helps to protect you against ineffective assistance of counsel. It's like, well, here's all the things I thought of that I've spewed on the page. I don't really think there's anything here. I very much prefer to be withdrawal now. But yeah, okay. This procedure will assure the penniless defendant the same rights and opportunities of appeal as near as practical as those who are persons who are in similar situation but able to afford retention of counsel. Yeah. Now, I suppose the really rich person can consult a number of attorneys and find someone who will find some merit in it. But again, under the Constitution, you have the right to a attorney, right? So it's not a completely even field because the rich person can consult, basically as many attorneys as he wants until he finds somebody. The Constitution only gives you the right to a attorney. So if the first one we assign to you says nope, well, we gave you as much as the Constitution required. But at least we're giving you something, right? We're giving you something. So, okay. And thus we reverse the judgment of the court. And then there were 3 dissents as well who think that, what California had was perfectly fine. So that's going to bring us pretty much to the end of our discussion there. There's no one in the chat called Lucy Rambo, is there? And if so, why are you sending me random email messages? But, okay. So that's basically what we've learned. So this is the Anders brief. So he has the right to an attorney. He has the right to an attorney. He'll be assigned one if he wants one. And his court-appointed attorney it could say, you know, that everything's frivolous, because I kind of think everything is basically frivolous. So you can file this, you have no hope appeal. And that's what the law allows for. Is sovereign citizenship frivolous? Yes, that claim is frivolous, for sure. But it's not whether or not, the question is whether or not all of his claims are frivolous. So like, for example, the potential grounds of appeal would include such things as he didn't knowingly waive his right to an attorney, or the judge abused her discretion when like throwing him out of the courtroom and stuff. But like basically everything's frivolous. There's nothing non-frivolous here. The judge, as we've noted, bent way over backwards to give him every right. And even the prosecutor bent over backwards to give him every right by, like, when the judge said, well, I'm not going to give you a closing argument, the prosecutor says, well, what if we try this? So even the prosecutor was trying to preserve his rights. God bless them. So, yeah. Is Lake Creek Parkway an office? No, it's not. It's a mailing address. You're trying to drive to my office? No. Lake Creek Parkway is not an office. It's a mailing address. It's a mailing address. I have someone who so Lucy Rambo is in chat and apparently is trying to visit me at my office, but it's listed as a mailing address. It's not an office location. So no, I'm not that dumb. Yeah. I live at my house, so we'll watch out for Lucy. Yeah. So Lake Creek. No, Lucy, it's not an office. At Lucy. No. It's a mailing address. Good times. So yes, we have someone trying to visit me in my office. It's a box for it, yes. Which, incidentally, if you look up the address on Google Maps, you'd be able to tell that, by the way. It's not like a massive issue. If you look up 9741 North Lake Creek Parkway, you'll just see that it's a UPS store. It's a mailbox. So, you know, good times. When I get a chance, check my email. I have checked my email. I have checked my email. That's why we're having this discussion. I've driven here from Sweeney, Texas, left at just 1 p.m. Arrived 2 were at a store near Walmart. Probably wasn't the smartest thing I'd done by desperately needing help. Then she gives me a phone number, which I'm not going to read. Hope this email gets to you as I've tried before. Lucy will be in chat unless I'm looking for an address to get closer. I need rest. Being 66 is older than I thought. Yeah, no. No, not so much. So, yeah, he has no chance for appeal. Yeah, he has no chance for appeal. This is exciting. What happened to the Reddit post? The entire forum was banned by the Reddit administrators, which is pretty happy. And also, I'm not currently licensed in Texas, that too, which I've made a point numerous times of saying, right? Every time it's come up, I've always said, every time I've passed the bar, I'm not licensed. I've said it. I said it in my bar passage video. Every time anyone ever says it, like in any chat, anything, I always correct them. Like, because I've been congratulations on being licensed in other people's chats. And I still make the point of saying I'm not licensed. I still have to get sworn in and stuff. So yes. So because I know I have to, you know, be clear about what I am saying and what I'm not saying, right? Yeah. Yeah. So good times. How are my hours coming? I finished all my Texas hours. Thank you, Angie. They were very painful. I need to still do hours for Virginia. Unfortunately, there's no overlap. I looked into this, by the way, in the future. In the future, it looks like I'll be able to overlap all of them, maybe except for 4 hours. So, like right now, I have always owned. I owe Virginia 12 hours of CLE every year. It looks like I will be able to overlap all those hours with Texas, but maybe not the live hours, because Virginia also requires a live component, which you can do online, but you have to be live online, which don't ask, it doesn't make any sense to me either. Like, what's the difference between watching a video on demand versus it being live? Because it's the exact same content. But Virginia seems to think there's a difference for some reason. Whatever. Anyways, so those 4 hours might not overlap, but it looks like the rest of the hours will overlap. So in the future, when I do the 12 hours for Virginia, that should also count for Texas, and it should hopefully be enough for Texas. So I might have to do 16 hours in the future instead of 12. The reason I have to do 24 hours this year is because the Texas Law Supplement is, as the name suggests, a Texas Law Supplement. So obviously Virginia doesn't give you credit for that because it's a Texas Law Supplement, right? So none of those hours counted towards Virginia because of course they don't. It's because there's no commonality because it's a Texas Law Supplement. So I had to give Texas 12 hours and I still owe Virginia now, I think 10 plus 4 hours live, which I'm looking to do on the 31st. So yeah, good times. Yeah. Yeah. So good times. Yeah, it's crummy they make you do it live, particularly because it doesn't make any sense. It doesn't make any sense, right? You can do it online live, but it has to be live. You can do the remainder hours on demand, but you 4 hours have to be live. But what's the difference between watching it live and watching it on demand? In terms of the content, isn't it exactly the same content? So why would it matter? I don't know. It's just what Virginia wants. What's the commonality? Oh, most law is what would you say? Or most CLEs are what would you say? They're taught at a high enough level that they can cross over multiple jurisdictions. So yeah, most CLEs are not hyper state specific. So most of the time you can get credit for multiple different states because they're broad enough to cover enough topics that they're relevant to multiple different states. The specifics of state law, of course, are going to turn on it, but they're broad enough to, like, they bring you up on trends and stuff like that. Teresa says, what happens when 2 cases conflict? I don't understand the question. What do you mean by that? Could you clarify what you mean when you say when two cases conflict? You mean two common law cases? Well, typically, if there's two cases that conflict, the next level appellate court resolves them. That's typically how it happens. And sometimes, every once in a while, you have two cases from the highest court which conflict. And then usually the highest court at some point resolves it. But every once in a while, they don't. I remember this came up in, what was it? Like, we did one time where it was Washington State, maybe, or it was something. I forget what it was. But we ran into a situation where the highest court, the Washington Supreme Court, maybe, the Washington Supreme Court had two decisions which were totally in conflict with each other. And like the attorney was saying, these are totally in conflict with each other. And the Supreme Court reviewed them and then refused to like change either one. So I just don't know at that point. Because like you have two cases that are literally in conflict with each other. Both are from the highest court. Like, which one is it? And the Supreme Court just says they're both good law. So we did run into that situation. So what happens if that situation happens? I don't know. Madness? I don't know. But yeah, that's normally you appeal it until a higher court reviews it, and if they're just in conflict, then I guess we're just in conflict, and there's nothing to do. So, but fortunately, that doesn't happen very often. It was a bit of an aberration when I saw it that one time. Yeah. So we did cover that one time on my channel. I think it had something to do with landlord-tenant law. I don't remember exactly what, but we did run into a situation where like these two decisions are totally in conflict, and the Supreme Court then refused to resolve the issue. It was an interesting moment. It was just right up there with the bee fish moment. It's just like, okay, bees are now fish. Bees are now fish, and both this and not this at the same time. Okay, that's just my reality now. Okay, both A and not A at the same time. That's great. What's the next live court cases I'll be covering? Well, I'll be covering the Crumbly parents trial. I know Ethan Crumbly himself just pled guilty, but the trial with his parents, he was a school shooter, by the way, for those of you who are not familiar with the name Ethan Crumbly. He was a school shooter. He just pled guilty recently, but his parents are also on trial. And I think the factual and legal case against them is interesting and not at all clear. I'm not saying that they're not guilty or something, but I think I'm a little bit dubious that they can be legally held responsible, to be honest. And so I'm looking forward to covering them because I think the legal and factual case against them is clear. I'm not sure the law really forbids what happened, and if it does, I'm not sure that they did the thing. So it's both legally and factually interesting, at least to me. Another case I'll be covering is the Murdaugh trial. That's probably the next one that will come up on my channel. Based on the timeline of such things. That's supposed to happen in January, I think. So the Murdaugh case is a murder case out of South Carolina. There, of course, the law is clearer, and the facts are pretty compelling. But, you know, it's a very interesting thing for deep South Carolina. So the Murdaugh case out of South Carolina is something that will be broadcast on here. Also, at some point, maybe, depending on what happens and the court's attitude and whether or not they change their decisions, Laurie Vallow, Chad Daybell case. The judge said no cameras in the courtroom, but that case has also been postponed. And also Laurie Vallow's case has been delayed indefinitely. And also Chad Daybell's case has not been continued. So it looks like they're going to be severed. So maybe one of them will be broadcast or not. So if that happens, we might do one of those. I'm trying to think what else is happening. Yeah. Well, Lucy, if it's an issue now, I am not licensed in Texas. I can't give you advice. I'm not licensed in Texas. I've never held myself out to be licensed in Texas. Every time I've ever discussed the bar, I've made it abundantly clear I'm not licensed in Texas. For exactly this reason. I'm not licensed yet. maybe next month. But I'm not, so I couldn't give you advice even if I could meet you. You need to consult, if you need legal help now, you need to consult an attorney now. Not that there's any shortage of attorneys in Austin. It's a big city. So like, you know, go find somebody. But I couldn't give you advice even if you could locate me right now. I've never held myself out to be a Texas attorney, ever. Because I'm not. I'm not licensed yet. I'm licensed in Virginia. That doesn't really help that much. I cannot recommend anyone. I don't know anyone in Austin to recommend. I'm not a lawyer here yet. I haven't worked with anybody. So I can't recommend anybody. I don't know anyone in Austin to recommend. I don't know who to recommend. You could look online for one. That's two. You could also, I don't know that they're open now because it's 6 o'clock Central Time. But you could try contacting the Austin Bar Association or the Texas Bar Association. They're probably not open at 6 o'clock in the evening, but that would be another way to get referrals from the Austin Bar Association or Texas Bar Association. That's normally what I recommend for referrals. If you need someone right now, you could check out avvo.com or Martindale Hubble. They do attorney reviews. Martindale Hubble, AVVO. That I would recommend trying to contact a couple different people depending on your issue and time. You could always, of course, just drive down the highway because you'll probably run into a few legal offices. Maybe one will be open, and maybe they can give you a referral if you need something right now. So, are they still televising the Murdaugh trial? Last I heard. Yeah, Ty is Tyler. Yeah, Ty's like a good 2 hours from here. Attorney Tom is in Houston. That's 2 hours away. Other lawyers I know in Dallas. I don't know anyone in the Austin area. But those are my recommendations for finding lawyers. It's good recommendations for everybody. Call your state bar association and your city's bar association. Those are good places to start. So that's pretty good universal advice. If you need an attorney, call your state bar association and your local bar association. They can help you out with referrals. If you want to look online, AVVO and Martindale Hubble are the two best websites I know of. In any case, I'd recommend talking to not less than 3 and probably not more than 5 attorneys because you want to get a good sense of who they are and a good feel for who would be right for you in your particular case. Would be my recommendation. Some of them will charge a fee to consult with them. Some of them won't. So some of them will give you a consult for free. Depends on the attorney. Some will charge you a modest fee. Usually it's like $150 for a consult, which is incidentally is much less than their hourly rate. They just want to like make sure that you're serious and not completely wasting their time. But those are my recommendations. State Bar Association, City Bar Association, Martindale Hubble, and AVVO. Yeah. So that's the best way to go. Yeah, and I finished the Texas Bar Supplement, so now all I'm waiting for is character and fitness review, which hopefully will resolve soon so that I can get sworn in on the 14th along with everyone else. If I have to wait, I'm going to be a little bit pissed. Because technically they have 270 days, which won't expire till January. So that's annoying. So we'll see. Do I have any more of the Daybell love letters? Yeah, I guess. I just don't really want to read one right now. What's my bio and career history? I've been a licensed attorney in Virginia for 15 years. Uh, yeah. I'm not sure exactly when I was sworn in Virginia, but it would have been about this time in 2007. So, yeah, 15 years. Great. I've been a licensed attorney I've been a licensed attorney for 15 years. My field has been in patent prosecution, which is the paper side of patent law. That is that's relating to drafts, drafting documents. It's relating to consideration of prior art, consideration of legal authority, consideration of patentability, and so forth and so on. So I've been on the transactional side of patent law for 15 years, and then I quit in July, and now I'm doing this, and I'm going to now be doing something else, probably appellate law or something, but that's a decision for another day. So that's basically my bio in brief. I didn't go to the gym today, no. Are you ever going to address subject matter jurisdiction law? I've talked about it. Yeah. Is Darrell Mother going to be on the hook for bail jumping, seeing as she posted bond? Yeah. Yeah. That bond will be forfeited. Sure. So yeah, he cost his mom some money, so that's great. I mean, at least as far as I understand the relevant law, maybe Wisconsin's different. Maybe she won't be able to money, but typically, yeah, the bond is to guarantee your appearance. And so, yeah, typically the bond is forfeited. Other than reputation, what general trait do you recommend to look for in a lawyer? A lawyer is a relationship like any other relationship. I suppose the answer I'd give is broadly the same answer I'd give for kind of basically professionals in general. Like what you would look for in a lawyer is kind of like what you'd look for in a doctor, or what you'd look for in an accountant, or what you'd look for in, basically any other position that you'd hire. You want to look to someone who understands you and understands your issue, and someone you can communicate with, and someone who you feel like you have some good rapport with, because there's a lot of trust in that relationship. So you're gonna try to find and you are extremely well advised with respect to hiring attorney to hire someone that you are willing and able to have them tell you no. Because no might be the right answer. It's not what anyone wants to hear, obviously, but a doctor can't fix every problem, nor can any other professional, right? A doctor sometimes has to say no. They say it differently, but you understand, like, that's not possible. We can't do that, right? And so attorney might have to tell you no. And like, you can consult a second or third opinion, obviously, and maybe a second or third opinion would be warranted, which is one of my reasons for suggesting you should talk somewhere between 3 to 5 attorneys, right? You should talk to not less than 3 and probably not more than 5, because you don't want to like get too much overwhelming information. But you're probably well advised to hire somebody who you will be able to tell you no sometime, because no might be the right answer. So those would be my general suggestions. Casey Starr says, my lawyer didn't speak to me once, all is paralegal. See, that's a bad sign, Casey. If your attorney won't talk to you, that's a pretty bad sign. Did the attorney talk to you? It is a pretty good sign. Yeah. Attorney would also never believe me and was irritating as I didn't lie all the time to make up stories. I mean, I can't speak to your particular attorney, but attorneys see all kinds of shit. And so whether or not you're telling this truth and whether or not the story to an outside observer seems incredible or incredulous are 2 different propositions, right? So like, attorneys see a lot of shit, so they might dismiss something out of hand because, we all operate by heuristics, right? We all operate by shortcuts. If like 99 times out of 100, it's shit, you're probably not going to look for the 1%. And so you might have to look a little bit harder to find somebody who is willing to dive into it because, you know, the attorney's like, well, I don't believe you. If it's true, find someone else. It doesn't say anything bad about that attorney, at least in my judgment. I mean, as long as they weren't like being completely rude about it. But, you know, attorneys have to make judgment just like anyone else. You know, if you tell someone a story, they cannot believe you, even if it's true. Attorneys are just human beings, remember? So just, you know, deal with that. Yeah, Lucy, that is decidedly a legal question. I can't answer that question. You need to consult an attorney. You need to consult an attorney on that one. Yeah, you need an attorney. Call your state bar association, call your local bar association, call Martindale Hubbell, or look them up. Look up avvo.com. Talk to a couple different attorneys. Find one that will work for you and represent you. You know, that's all I can really give you advice to do. You know, the only ethical advice I can give is to consult an attorney. And it's not me because I'm not licensed. So, you know. How do you find an attorney willing to sue DCYF? I live in New Hampshire. Everything I just said, all the things I just said. My advice is no different for New Hampshire or anywhere else. How do I find an attorney who's going to sue this person? Just do all those things I just said. If you can't find any attorney who's willing to take your case, maybe it's not a good case. I mean, I don't know, and I'm certainly not going to evaluate it myself. I'm not licensed in New Hampshire either. When I get licensed, what are my plans? No plans. I'm going to continue doing the YouTube thing for the indefinite future. I'm going to continue doing the YouTube thing for the indefinite future. And beyond that, maybe I'll do some piece work or contract work or something. Do some appellate work for like Ty Beard or Attorney Tom or both or whatever, right? Just try to do some piece work and, you know, just kind of putz around a little bit while I'm doing my YouTube thing. We'll see. Do I have to do pro bono work? No, I might do some pro bono work, though. That'd be cool. I don't know how it works with indigent defense here in Texas, whether or not they hire private attorneys or not. So I might try to do some indigent pro bono criminal defense or something. That might be fun. We'll see. You suspect attorneys will be hesitant to sue state agencies? I think that's wrong as a matter of general principle. Attorneys sue state and federal agencies like literally all the time. There are attorneys who specialize in it. There are attorneys who specialize in suing agencies and winning, depending on the issue and the agency and everything else. Like, so you think attorneys will be hesitant to sue a state agency? No. Not if there's a good case. No. Finding an attorney who's willing to take on a good case that requires suing a state agency, I don't think will be a problem. I think you'll be fine. Shouldn't be hard. You'll be, yeah. Yeah. Should be hard. Seem like a decent person? I try to be. I seem to be a decent person. I would sue a state agency in a heartbeat if I thought warranted. Like, I don't know that that's what I wound up doing. But if I had a case, if a person came to me with a case that would require suing a state agency, I have zero problem doing it. I would sue a state agency in a heartbeat. No problem. I don't care. If they're in the wrong, they're in the wrong, right? The government can lose in its own courts just like everyone else. That's fine. Is it a conflict of interest for a law firm to contribute to a political campaign while representing a government agency? I don't know. I'd have to really consult my conflicts of interest law. When do I get Texas licensing? Hopefully next month. Hopefully on the 14th. Would I sue my employer who's a school district? Maybe. If the circumstances were right, possibly, sure. If I had a case, sure, why not? Why wouldn't I sue a school board? I don't care. Yeah. Criminal, civil, family, or general? In terms of appeals, I do like general. General appeals. I'll do all appeals. All comers. I had a legal professor in college who said anytime someone asked him if they had an ethics problem, he would say, I know you do, but do you want to tell me about it? Okay. I mean, attorneys sometimes run into ethics problems without them being ethically violating. Sometimes attorneys run into ethics problems. It happens. There's hotlines for it to get advice. I mean, I've never been in that situation, but you can be in a situation where you reach a situation where you're like, you're not sure what the ethics rules are. Be like, I don't know what the ethics rules are here. It can happen. Just like any other law, right? The ethics laws are just like any other law. The laws are sometimes ambiguous or there's some reason maybe to like look past them in some way or something. I mean, the ethics laws are not written with absolute total precision anything more than anything else is. I mean, you can run into problems. And you can also run into problems where like the ethics rules themselves are wrong or unethical or illegal. We saw that, for example, in Pennsylvania when they adopted the model rule 8.4, which basically was wokeness for attorneys. And the Pennsylvania district court, the federal district court, struck down because someone sued the Pennsylvania State Bar, a lawyer or a law student, I forget which one. But a lawyer or a law student sued the Pennsylvania State Bar and said, hey, Pennsylvania State Bar, this rule you've adopted is illegal. And they won because it was. So, I mean, the ethics rules themselves could have a problem with it. I mean, so it's like, things happen. What about Cornell Legal Information Institute or Fine Law for Finding Attorneys? I'm not familiar with those particular websites, but sure, why not? Stop being mean. I'm not being mean. Am I being mean, chat? I thought I was being fairly cordial. Yeah, I'm just being straightforward. I'm just telling you, like, straightforward. I'm not trying to be mean. I'm just like, I can't do this. I've made abundantly clear as much as I can that I'm not licensed. I can't represent you. Here are some solutions that might work for you. Here's some places you could call or numbers you could call, or here's some things you could do, or, I mean, I'm trying to point you in the right direction within the bounds of ethics. I can't represent you. I can't give you individualized legal advice. The only ethical advice I can really give you is hire a lawyer. And then I can say, okay, here's some mechanisms by which you might go about doing that. Martindale-Hubbell, AVVO, State Bar Association, Local Bar Association, driving down the street, consulting 3 to 5 attorneys, interviewing them. Here's why you'd be interviewing them. Here's what you're looking for. You want to find an attorney that works with you, understands your case. You want an attorney who can probably tell you no. Here are some ideas of things to look for. That's about the extent of advice I can give. Consult the state bar association, consult the local bar association is pretty good advice. AVVO and Martindale Hubbell do attorney ratings. I've used those particular sources in the past as a mechanism for getting initial names. And then looking into them further by doing further diligence research. Consult with a couple different attorneys to find someone who can help you in your particular case. Okay, well, apparently I failed in some way. I'm not sure how, but apparently I failed Lucy in some way. I'm not sure how. I did my best. Anyone else? All right. Well, I'm going to sign off. And if you need advice of your own for your own attorney, it's the same generic advice. I live in state X and I have problem Y. Where can I find an attorney? It would be my same exact advice. This is nice universal advice. Like, regardless of what state you live in, regardless of your issue, these are good mechanisms to find lists of attorneys. And then from there, you want to do your own due diligence, which is why I said interview not less than 3 and probably not more than 5. You want to go to at least 3 people, because if you have a problem, you have a problem. And you want to go to at least 3 people, because maybe those people can't help you. Maybe those people can give you names. Maybe those people will give you referrals, right? I'm not the attorney for this, but I know so-and-so and he can help you. That happens all the time, right? Or they think they're the attorney for you, but you realize they're not, or you realize they're not, or whatever. It's like you want to consult a couple different people and do your due diligence and find someone who listens to you, understands you, someone you can communicate with clearly, someone who's giving you appropriate respect, and probably for your own benefit, someone who you are willing for them to tell you no, because no might be the right answer. And you want an attorney who can tell you no. If you insist upon an attorney who can never tell you no, then that's where Amber Heard had her problem. That's basically why you want an attorney who can tell you no. If you want the one thing that went wrong with Elaine Berdoff, in my opinion, the one thing that went wrong is that for whatever reason, she was unwilling to tell Amber Heard no. She surrendered too much of her professional control to the client. And in doing so, walked up with a worse result than there were possibilities for. We saw second chair. He had better arguments that he could have won that case. You want someone who can tell you no, because if you have someone who just tells you yes, basically you wind up with Elaine. And no one wants to wind up with Elaine now, do they? So you probably want an attorney who will be willing to tell you no, and someone who might, actually be willing to tell you no. So, yeah. All right, I'm going to sign off for now. This has been fun. I'll be on later tonight. We'll do another case tonight. And that'll be fun. I'm very happy for the people of Waukesha that got their justice today. And it pleases me to no end to imagine Darrell Brooks in his own personal 6x9 cell somewhere where he can be a sovereign citizen for the rest of his life. He'll have all the sovereign citizenness he wants in his 72 square feet. And that makes me so happy. This thought warms the cockles of my heart. It's nice. It's a good day for justice. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.